right, and thank you, Jonathan. We do have another caller standing by. Welcome, LawCall, Teresa. And what is your question tonight?
I was hurt on the job with an on-the-job injury. I have been receiving workman's comp, which has been 66% of my salary for 2 years, which is $3,000. And last week, my adjuster told me that they were going to have to settle with me. I'm 62 years old, and I'll never be able to go back to work again. And my question was, what is a fair settlement?
All right, thank you so much, Teresa. And what is your advice for Teresa?
Well, Harry and I talked about this a little bit out of the set. What's frustrating about workers' comp is that when you're evaluating a claim, when it's time to settle, much like Ted, the insurance carrier's tired of taking care of Teresa and they just want to get her off of their books. They don't want to get into what's called their reserves and impact how much money they have. They don't want to reallocate funds and take care of other people and take out of one pot and put into the other. So it depends on what type of injury she has. We have scheduled member injuries like the arm or the hand or the foot. We have body as a whole injuries. We also have to consider what wages has she lost if it's this full body claim. If it's an injury to an extremity, a scheduled member, then we're really looking at what's the loss of industrial use, which I explain as what's the implication of the injury had on my ability to do the job. But what's most important in all of this is what do those medical records say? Much like what Harry does, this all lives in an injury claim. And so, can I do what I used to do? And if not, why? What are my restrictions? What's my anatomical impairment rating? We take those numbers, we put it into an equation, and we don't pull it out the ethos. We have something that tells us this is the value of your claim. Now, with an efficient workers' comp attorney, we will get more money because the act does allow that judge to deviate from the anatomical impairment rating and go up. So oftentimes, for example, a rotator cuff surgery, you're going to get 12 to 15% of impairment rating. We can go and get you more money than what that actual value is. So my advice is always get you an attorney, file your petition to controvert. Even if you've gone the whole time on the workers' comp without an attorney, we can always come in and help kind of put the puzzle together.
Okay.
That's right.
Let me ask, so like if I settle a case, I don't necessarily need to get permission, it's just really the client tells me I want to settle or not settle. And when Teresa says, what is a fair settlement, do you have to get it approved? Is someone overlooking the settlement?
That's right.
Saying whether it's a fair settlement, like the commission?
That's right. So procedurally what will happen is I'll go to the insurance carrier and I'll say this is the amount that my client wants, and they'll come back and have some number far lower than that. Right. I'm going to file a pre-hearing statement and bring you up to the courthouse if we have to, but usually they don't want to litigate all the way. So once you actually file it's a 9I settlement, it's a petition and an order, the judge will get that, and then it'll go up to the commission. The commission will review it, and as long as they think that your client's getting what they're supposed to and there's no unanswered questions, they're going to go ahead and approve it. Most of the time, they don't want to tell your client what they can and can't take.
I got you.
But it can happen.
Okay, that's great advice. Thank you so much for tuning in, Teresa.